Welcome. My name is Rachel Van Cleve, and I'm very proud to be the Dean of Golden Gate University School of Law and delighted to welcome all of you to our 6th annual Chief Justice Ronald M. George Distinguished Lecture. I remain grateful to my predecessor, Drusilla Ramey, who had the vision to start this lecture series, and it has really been wonderful being able to continue that tradition with what has really become a signature event here at Golden Gate Law School. I do want to thank our sponsors, without whom this would not have been possible. They are listed in your program. I also want to thank my colleagues who are here, law students who are here, lawyers in the community, and students at other law schools besides just Golden Gate. Thank you all very much for coming. We're delighted to have you here. And another group of people without whom this would not have been possible at all, my fabulous staff, Maggie Stone, Matteo Jenkins, and Eric Christensen, making sure that all has run smoothly. I also want to thank General Suter for being such a great sport. When I invited him, he said, yes, I will be there and fill my day. So we did. He joined us for our 2nd annual Veterans Conference this morning. And then he went to a constitutional law class this afternoon and spoke with the students there. He joined us for the advisory board for our Veterans Legal Advocacy Center this afternoon as well. And I have not seen him drink very much coffee, so I'm just amazed at the level of energy he's been able to maintain. I also want to thank Jeannie Suter for being here today on her birthday. Happy birthday. Happy birthday. We very much appreciate that. I would now like to introduce the Honorable Ming, Associate Justice of the California Supreme Court, who will in turn introduce our guests. Justice Chin also has an exceptional past, including his service as a captain in the Army with combat service in Vietnam, his work at the Alameda District Attorney's Office, and his work as head of the trial department at Aiken, Kramer, and Cummings. He is a principal contributor to the Reuter Group California Practice Guides on Employment Litigation, as well as Forensic DNA Evidence, Science, and the Law. We are very grateful to have him here tonight. Last year, he was our keynote speaker when we featured veterans in the judiciary. Please join me in welcoming Justice Ming.
Thank you, Dean. Thank you, Dean. I'm delighted to be back, and welcome to the Bill and Marcia show. It's my great pleasure and honor to introduce tonight's special guest, General William K. Suter, who will be joined in conversation by Marcia Coyle. Marcia is a chief Washington correspondent with the National Law Journal. She is a lawyer as well as a journalist. She covered the U.S. Supreme Court now, I think, 25 years?
27.
27. Time flies when you're having fun. She regularly appears on PBS NewsHour. Her work has earned numerous national journalism awards. She has a new book out. Well, it's not so new anymore, 2013. She was asked by Alice Mayhew, the senior editor of Simon & Schuster, to write a book on the U.S. Supreme Court. It's entitled The Roberts Court, The Struggle for the Constitution, and it has received rave reviews. Marcia wanted her book not, N-O-T, not to have a partisan viewpoint. What a novel idea. In praise of her book, historian David Garrow pinpointed precisely it is a non-partisan account of the work of the court. Kenneth Starr called it a wonderful addition to the literature of the court. Marcia, that's next on my reading list.
Thank you.
As our special guest tonight, I must confess that I'm in a bit of a quandary about how to introduce this man. You see, in his remarkable career, he has held the highest positions, both civilian and military, As an attorney, I'm inclined to call him counselor. As a judge, I'm inclined to call him Your Honor. But as an Army veteran, I feel obligated to address him as General Suter, sir. Of course, General Suter began his military career as an Army officer in 1992. In the next 30 years, he rose rapidly through the ranks. After serving in Vietnam, he became the Judge Advocate General for the Army's 100th Airborne Division at Fort Campbell, Kentucky. In 1980, he became the Commandant and Director of Academics at the JAG School. In 1984, he served as the Chief Judge of the U.S. Army Court of Military Appeals and Commander of its Army Legal Services Agency. From 1985 to 1990, he served as the Assistant Judge Advocate General for the Army and was promoted to the rank of Major General upon his nomination by the first President Bush. He was appointed to serve as the Judge Advocate General of the Army's highest-ranking attorney. He retired from the military in 1991 with legions of distinguished medals, but he certainly didn't let it all go to his head, nor did he let grass grow under his feet. General Suter immediately began the next phase of his life, the next chapter. He became the 19th Clerk of the United States Supreme Court. He served in that position from 1991 until last year. At his retirement celebration, the Chief Justice, John Roberts, used these words to describe the general's tenure: momentous, unparalleled organization and efficiency. Sounds like a military man, doesn't it? Calm, confidential, disciplined, proficient, inspirational leadership. High words of praise, indeed, from the Chief Justice. General Suter now writes for the Hoover Institute. He's a visiting fellow and also serves as a consultant in the biotech field. Last night we talked a bit about Lyme disease. I asked Bill what he knew about Lyme disease. He said, not a lot yet. He has amassed a long list of civilian legal awards to go with his military honors, but he is also known for his extraordinary public outreach efforts on behalf of the branch, regularly meeting with law school with children, with law students, with foreign dignitaries to explain the unique characteristics of our legal system. Ladies and gentlemen, please give a warm San Francisco welcome to Major General William K. Suter and his sidekick, Marcia.
Thank you.
Well, thank you, Justice Chin, for the lovely introductions and the book plug. I appreciate that greatly. I just want to add that I am also very happy to share my evening with you, and particularly happy to share it with Bill Suter. Bill was always a very welcome presence in the press room at the Supreme Court. He tolerated us with good humor and great skill at avoiding revealing anything of the institution's secrets that we could use. So I don't know that we're going to get any secrets revealed tonight, but hopefully you'll walk away knowing a little more about the Supreme Court and how it operates, and hopefully a lot more about this fellow next to me. So I am going to start with, maybe you could call it a chicken, was it the chicken or the egg question? Tell us about your path to the law. Was it the military first that enchanted you, intrigued you, interested you, or was it the law? How did you come to the law?
Well, thank you, Marcia. Thank you, Mr. Justice, and the Dean, all of you for coming tonight. I thank this school for what you do for legal education and what you're doing for veterans. Dean, you're the best. Thank you. What led me to the path of the law was a professor. Don't they do everything for you? Your parents and your brothers and sisters and husbands and wives, they lead you in the way. I was nothing but a kid from Kentucky without much talent of doing anything in life, and I wound up at Trinity University in San Antonio, Texas. Why did I go there? I could not get a basketball scholarship in Kentucky. I tried the powerhouses of Kentucky. Transylvania College, Center College. I didn't think of the University of Kentucky. I was like Louis Grizzard said, that great writer. He said, "Shoot low, boys, they're riding Shetland ponies." So I was looking for the low-hanging fruit, and nobody took me as a basketball player. And my coach was so sympathetic. He said, I was at prep school in Kentucky. He said, "Bill, you're slow and you don't shoot very well." With that inspiration, I decided to get an education and went to Trinity University, had a great time, tried out for the team, made the team, and the next year got a full scholarship for 3 years. So Louis Grizzard was right. But there along the way, the next year I met my lovely wife, Janie, and that worked as dating for 3 years and married, now 55 years of marriage. So that was the best thing that led me to the law. But I had a wonderful professor of history who just told me, you know, you need to go on to graduate school. I think it should be law school. He got his doctorate at Tulane in New Orleans. He said they have an outreach program for scholarships for students outside of Louisiana. He got the forms and filled them out for me. Can you believe that? That's how great he was. And I got a scholarship to go to law school at Tulane. And so in the meantime, I had an Army commission to go in the Army, but the law just sounded interesting to me. I read about it, no lawyers in the family. I didn't watch lawyer TV shows. We didn't have much TV in those days. And so it just sounded interesting. And the professor convinced me to go to law school. The scholarship was also a great incentive to go. And Janie thought it was a good idea. So we put everything we owned in a car and drove from San Antonio to New Orleans. Remember those days? And so that's how I got there. But I was absolutely clueless. I didn't know one student. I didn't know one lawyer or one judge or anybody. But sometimes you should just start things that way, just clueless. So that's how I got started in the law.
But you were interested in the military as well. What was it about the military that attracted you?
Well, the draft.
Ah. Okay.
I wasn't afraid. My brother had been in the Korean War. I had 2 older brothers. And so I knew about the military. And I'd gone to military school, first through the 12th grade. I went to a boys' school for 12 years. It didn't ruin me. We talked about girls all the time, but it was a boys' school. That's only boys went there. But I knew I should take ROTC to get a commission, and I wanted to serve my country. I didn't know for how long, but I just thought, back in those days, your parents inspired you and others. Well, you should be in the Army. Well, of course, Dad. That's what I'm going to do. And I took ROTC, and I liked ROTC. It was a lot of fun. So I was commissioned at Trinity. They gave me a delay. I went to law school, then came in the JAG Corps.
Okay, good. Tell me, what were some of the greatest challenges that you faced while you were a military lawyer?
If you didn't have any challenges, it wouldn't be any fun.
Right.
I mean, that's really the truth. If your job's that easy every day, I'd go do something else. I like challenges. Now, only so many crises a month will be tolerated. But the challenges really were to think ahead, not for tomorrow, but the next month. Especially when you're a supervisor or a commander, you just can't say, everybody be here tomorrow, we'll get our work done. I was looking always over the horizon, we called it, and trying to plan that way, even as a young officer. And the people that taught me the most, I got to tell you this, as a lawyer, as an officer, as a judge advocate, were the non-commissioned officers, the sergeants, and the warrant officers, and the civilian employees who'd been around a while. People have a little bit of gray hair, they know more than I knew. And so I learned from them along the way. And they taught me how to plan, how to organize. They taught me all those things.
Well, you were in Vietnam for a period. Was that particularly difficult to be a military lawyer in Vietnam?
It was hard work. And I'll have to say this about all the officers, all the JAG officers over there. When I was there, I guess we had about 200. At one time, we had about 500. And most of us were not career officers. When I went to Vietnam, I was a major. I decided to stay in for a career. My boss at the headquarters where I was a World War II era full colonel. I mean, he had been in combat in World War II. There was him, then there was me. I'm 20 years younger, and there were 76 captains under that. We didn't have any middle management, and that created a little bit of a problem. None of those captains were careerists at all. But I got to tell you this, my friends, they went over there, and did their duty. They didn't go to Canada. I'm not critical of people here. I'm just saying they didn't do that. They went over, they did their time in Vietnam, and came home. They did it. They worked hard every day. It was hard work, but the harder the work, the more they liked it. I mean, they were in that office. We made them go home on Sunday. They couldn't come to the office on Sunday unless you wanted to write letters home or something. And so they did a great job. I'll tell you a quick story about that. There was a crime in Vietnam called fragging. You take a hand grenade, you take the handle off, you put a rubber band around it, put in a can of gasoline, set it under somebody's floor, and the gasoline will melt the rubber band, and the grenade goes off and kills somebody. It's indiscriminate, or hurt them. It was hard to catch those guys that were doing fragging. It really was. But a fragging grenade went off one time under we call it a hooch, under a floor of a building, and seriously injured a major who was in bed up above it. The guy who did it bragged about it. And some other evidence came up, and we had enough evidence to try him. The young fellow that I appointed as a prosecutor was named Jimmy Pooh Wilson from Alabama. Now, I don't know why we called him Jimmy Pooh, but that's what he was called. Not a careerist at all, and Jimmy was preparing the case. It was a difficult case to prosecute. Then Jimmy got sick, and I hate to say this, he started throwing up in the office in a bag. And it was rather, annoying, but so the doctor said, Jimmy, your esophagus is going the wrong way. You've got to ship you home for surgery. You've got to go home. And he told him, you go where? And came back up to the office, and I found out about it, and I went in. I'm a major. I said, Jimmy, you have to go home. He says, no, sir, I refuse. He said, I've got to try this case. I said, Jimmy, please. He said, I refuse it. What are you going to do to me, sir? Right? So Jimmy lost weight. He sustained himself on milkshakes and got a prosecution, got a conviction, got a great sentence. And then we took him down to the hospital, and I pinned a Bronze Star on his pajamas, and he went home. That's dedication. He's not a war hero. Never heard from him again. I don't know what happened to Jimmy Pooh. That's kind of, you veterans know out there, it's the story of walking in and out of other people's lives, being in the military. But they're your brothers and sisters, and you really love them. And that was an inspiration to us, to see old Jimmy, everybody crying. Off he went. So these were dedicated people over there. But we had problems just getting out to fire support bases to try cases, finding witnesses. You say, where are these witnesses? Well, they've gone home, back to the States. We'd have to bring them back. Then you had a cost analysis. Do we really need to try this person or not? These were hard decisions. Then, of course, the drawdown. I was there doing a lot of the drawdown. Who goes home first? Well, you say, well, everybody's been here 12 months, go home, then 11 months, 10 months. Can't do it, my friends. You need a skill balance to sustain the force. So many cooks, so many helicopter pilots, so many mechanics. What if all the cooks go home? Right? What if all the pilots go home? Aviators, we call them. All right. So you had to have a skill balance, and I was on a team that worked on that, the entire drawdown. I found that exhilarating. I like that kind of work. I like management work like that, yeah.
I was going to ask you if there was an area of military law that you particularly enjoyed or found challenging, but it sounds as though you really thrived when you had to do management more than, say, trying a case.
Yeah, I only tried cases for 3 years, my first 3 years, and I defended cases for 6 months, and then I prosecuted cases. But then you sort of, I hate to say, you grow out of that and do other things. But every day something new comes in. I'm sitting in my office in Vietnam one day, not a very nice office, but call came in and there was a code. It said, Major Suter? I said, yes. They said, egress recap. I said, oh my God. That was a code word. It meant we got a POW back. Put the phone down, ran out. Sergeant Major said, where are you going? Can't tell you, Sergeant Major. Got in my Jeep and drove down to the 90th Vac Hospital and got in line, and one of our POWs had sneaked off and got away from the Viet Cong. Wow. So, and not the North Vietnamese, the Viet Cong had him. So my job was to go in and say, soldier, how are you? I'm your lawyer. Do you have any legal problems? I felt like a fool. First thing, the doctors and nurses saw him, but then the chaplain saw him, and then it's the time for the JAG to go in. And here's this kid from down south someplace. I mean, just right off the farm. He's lying in the bed with his feet sticking out from under the sheets, and his feet were swollen like this. Bug bites. He hadn't any shoes on for about 2 years. And he looked okay up here, but down there, he was terrible looking. And I said, son, you're going to be going home. I'm sure you don't have any legal problems. He says, I don't think so. I said, well, that's good. He said, oh, sir. He says, I was locked up 2 years. Do I still get my R&R? That's your week off of rest and relaxation to go to Thailand or someplace? That's what he was thinking of after 2 years of locked up. That's not a legal problem. I said, son, you're going home. He said, okay, sir. I just was asking.
I wanted to ask you something a little more contemporary as well. As you probably know, in fact, there's a big case that was argued just this week in the D.C. Circuit. There's been considerable debate over whether alleged terrorists or enemy combatants should be tried in our federal or military courts, particularly because of problems that we've seen and delays experienced with military courts at Guantanamo Bay. And I was wondering, after seeing both systems, in your opinion, is one system more appropriate than the other?
Well, I think, Marcia, there are really three systems. There's your domestic criminal cases,
True, yeah.
your stick-ups and this and that, which you try in state or federal court. They work fine, I think. You have the court-martial system, which is applicable everywhere. By the way, Article 2 of the Uniform Code of Military Justice says this code is applicable in all places. One of the best sentences ever written. Today, lawyers would say this code and all amendments made hereunto after shall be applicable and have full force and effect in all places, including space, underwater, so on and so forth. The Uniform Code of Military Justice applies everywhere, so I think it works pretty well. Then you have this in-between, military commissions.
Right.
You know, it seemed to work quite well after World War II, and there were two kinds of commissions, the joint commissions with other countries, and those commissions in the Pacific, which were military only, U.S. military only. They worked fine. Was it total due process like we have in our domestic cases? Well, of course not. The witnesses aren't there and so forth, so you have to modify the rules a little bit to make it fair. It worked fine. And the Supreme Court upheld it. Estenberger, I think was the name of the case? Eisenberg. Upheld it. So I thought when the cases came up to the Supreme Court out of the Gulf Wars, we'd do it the same way. And it didn't work out that way. I think it was a horrible mess. I kind of wish that courts had stayed out of it and let the military commissions work. You do have all the due process they can give them. Were there mistakes made? Yeah. There were allegations that they were listening in on conversations and so forth. Of course, they shouldn't be doing that, but you can go on and have the trial. I think it would all been over with, the trials, had people sort of left it alone. Now, that's a simplified version, but I think we missed our bet after World War II ended and all the trials took place. By the way, Nuremberg was just one war crimes trial. I'm sure you all know that. There were hundreds and hundreds and hundreds of war crimes trials all over Europe and the Pacific. Nuremberg was just the big one. I kind of wish Congress at that time had said, you know, we need to codify this into a little body of law that's sort of in between full war and you know, not war, not domestic. It's this body of law, and I think they could have done it. What they did was they tried to legislate on the fly. You know, they were amending that law every couple of days to try to stay 2 steps ahead of the Supreme Court, and that's not the way to legislate. I'm not blaming Congress or blaming anybody. It's always easy to say, we should have done. Maybe I should have done something about it, but I wasn't around. And I wouldn't have anyway. I wouldn't have had the common sense to do it. Once World War II ended, we said, peace, prosperity, let's get on with our lives. Greatest generation, it's all true. And we didn't worry about it because there'll never be another war. Well, wrong. So I think it could have been, I wish it could have been handled cleaner. They deserve fairness. But it's kind of like Chief Justice Rehnquist wrote a book. It's called All the Laws But One. Very interesting book. And it was about the civil rights in trials in time of war. And there's a Latin phrase, it's about this long, I don't know it, although I took Latin for 2 years in high school. And what it really says is, in the time of war, the law is silent. You've all probably seen that at one time or another. He said, that's not really right. He said, in time of war, the law speaks with a different voice. I thought that was just brilliant for him to do that. And he wrote that book before the Gulf War cooked up and everything. He also wrote grand inquests about the impeachment of President Johnson, the older Johnson, not Lyndon Johnson, and the impeachment of Justice Salmon Chase. And he wrote that before Bill Clinton was impeached. So I asked him about both these books. I said, did you have a dream? He says, never in my wildest dreams did I know I'd be sitting on the impeachment of a president when I wrote that first book. Of course, once that all broke loose, that book had to be reprinted in about 1 million copies. But I recommend you reading Grand Inquests and All the Laws But One. Chief Justice Rehnquist was a very talented writer.
Yes, he was.
That's a very long answer, Marcia. I apologize.
That's all right. Why did you decide when you retired from the military to seek the position of clerk of the Supreme Court?
Students will appreciate this answer. I needed a job. Before I retired, I started looking around. I'd never looked for a job. You go where you're told in the Army. So I got busy and wrote a resume and read some books, did some talking, talked to a lot of people, and started sending out resumes, and I got rejection letters. I call those character builders. They always say, you are so well qualified, unfortunately. So I could open it, oh, thank you very much, but then write a thank you letter back. I learned to do that. And applied at the Supreme Court. A retired general's wife saw in the Washington Post that my predecessor was retiring. Called my wife and said, that's a great job. Bill would be perfect to be the clerk of the Supreme Court. She told me, and I told her, I said, honey, look, those jobs are political. They're like Fishbait Miller, the doorkeeper of the Senate. I've seen that stuff before. It's all tied up in politics. And she said, don't you know a retired sergeant major that works at the Supreme Court? I said, yeah, Charles Cornelius. And she said, why don't you call him? So I called him and I said, Charles, is this a setup? You've seen these before, haven't you? They advertise and everything, but nah, they've already picked her. That's okay. He called me back a couple days later. He was very well liked at the court. He said, no, it's wide open. So I gave my resume to another clerk of a court to look at. He had it over the weekend. When Monday morning he came and gave it to me. It was full of red ink. I was using Army terms that nobody would even understand. I was an idiot. He shaped it up to make me look like I could really be a clerk. And so, really, he did. And a wonderful gentleman that helped me with that. A veteran of the World War II, Korea, and Vietnam, by the way. And so, a great man. And so I submitted it, forgot all about it. A friend of mine offered me a job to be a special counsel to a corporation and work from home, which was kind of nice. So at least I had a job. I told my wife, I said, we won't starve here, we're all right. Then got a call to go down and be interviewed at the Supreme Court by Justices O'Connor, Kennedy, and Scalia, which was an interesting hour.
I was going to ask you about that.
Yeah.
And what were they looking for in a clerk? Can you say sort of what was the interview like?
Well, it starts off, Justice O'Connor, of course, is the senior. Of course, Jeannie had dragged me off to Nordstrom's to get dressed. And so I wore my due interview suit down to the court. And she asked the icebreaker, she said, tell us about yourself. Students, when they ask that, give a very brief answer. That's called the icebreaker. Don't say, well, I was born in a hospital, and just briefly say, and here I am. And then the conversation got to just about anything and everything. And so they were just interesting questions. And at the end of an hour, they told me, thank you for coming. And Justice O'Connor came over and said, thank you for being here. That's a lovely suit. I went home and kissed Jeannie and said, you're right again. You know? So it just all sort of happened, and met with the Chief Justice, and he offered me the job, and less than 10 days later, I was out of the Army and I was there. I went the next day.
Right.
Yeah.
What was the first day on the job like for you?
Well, I was clueless. I was just sort of...
You never had been a clerk of court.
No.
Any court.
You know, though, I had an old World War II veteran, flew 56 missions in Germany, pretty tough old bird. He was a 2-star general when I worked for him, and he would say things like, Bill, you don't have to be a horse to judge a horse show. And so I had been a chief judge of an appellate court in the military, and I had a wonderful, wonderful clerk. And so I knew a little bit about what they did. It's got to be organized. You've got to find out, what does the court want? What do they need? And then go about it. So the transition, people say, gosh, how'd you transition? You're in the Army. It was easy. You have a mission, an organization, a hierarchy, it's a structure. You have limitations on what you can and cannot do, what you should do and should not do. You've got a staff. Now get the work done. So I didn't see any difference. Will's probably the same way right here. He went from a structured environment. I mean, he went from the Air Force Academy, and then flying around in airplanes all those years, and then went right into another organization, then to another organization. Did you ever see any difference, Will?
Yeah.
They're people. They're real people. And the so-called little people should not, must not be ignored. First, they're not little, and they're not insignificant. The people that work in the basement and do this and that, they're real people, and you support them, and they'll support you.
What's the environment like at the Supreme Court when you work in the court? I mean, we sort of are there, but we're not really on the inside.
You know, it's amazing. There are just about 450 people working there. About 150 are police officers. They come and they stay a long time. The justices have a very small staff, 2 secretaries, 4 law clerks who are there for 1 year only, and then they have 1 chamber's aide. That's it. They don't have this great big staff. It's small. And we're totally a little city unto ourselves. We have our own painters, plumbers, electricians, print our own opinions right there in the court. Everything is done in-house except laying carpets and things like that. But it's all done right there, and there's a sense, it's like the military, it's a sense of mission. Let me give an example. Case you've probably never heard of, Bush versus Gore. Kind of sneaked up on us, and we had gone, Jeannie and I had gone Friday afternoon, driven down to Charlottesville. I gave a talk, well, the same talk you gave, Abraham lecture at the University of Virginia Law School, and on the way down on the radio, I heard that the Florida Supreme Court had just stiff-armed the Supreme Court of the United States, put it that way, just sort of ignored our case that we remanded on Bush v. Gore, and in essence said, no, they count the votes this way. I looked at Jeannie and I said, that's crazy. We just remanded a case, and they ignored it and took another case, Bush v. Palm Beach, we sent back. They took Bush v. Gore and said, here it is. In essence, Gore wins. I said, I said, this isn't going to be good. Oh, no, what's going not the case, but I mean for us, what are we going to do up there with this thing? Gave my terrible speech, had dinner. We have a lake house near there. Went to the lake house, and I said, we won't spend the weekend here. Next morning, 6:30 in the morning, I got a call. You better get up here. Ted Olson's looking for you. Ted Olson was Bush's lawyer, later the Solicitor General of the United States. He was up there to file something early in the morning, so we drove back with blue jeans and a sweatshirt on, and Jeannie, I think you just dropped me off at the court, and I said, I'll see you when I see you, honey. And went in, and Ted was there all right, and he was ready to file an application to stay the judgment of the Florida Supreme Court and to treat that as a cert petition. Most lawyers don't think you can do it. Oh, yes, you can. Actually, you save $300 by doing that, but that's another thing. Ted was not interested in $300. But that day, just a few of us in there on Saturday morning started growing. The media got in there faster than anybody. They couldn't wait. This was red meat for them. They were loving every minute of it. And pretty soon I started getting calls from the clerk's office staff people. I hear, you're open. I said, yeah, we're open. We're okay. One guy ran the file room. He says, well, don't you need me in there? And I said, no, Calvin, we're okay. He says, I'm coming anyway. And pretty soon, here's the whole clerk's office coming in one more time, just in case we're needed. Nobody would dream about saying, do I get time and a half for overtime? I've got to go to the daycare center. No. There was a crisis. We can't even count votes in Florida. They can't follow the instructions. We don't know who our president's going to be. Are we a third world country or what? We got a job to do. We don't decide things down here, but we got this paperwork. We got to get moving right now. And it was amazing. The court decided very quickly to have the briefing done simultaneously. Usually petitioner files. 30 days later, respondent files. Oh, yeah. Chief told me, we did an order, electronic filing simultaneously within 24 hours. That'll make lawyers move, and not just lawyers. Technicians, librarians, staff people, they had to get with it, and it all got done. We had never accepted a brief electronically. But the Chief Justice looked me in the eye and said, can we do this? What did I say? Well, see? You're conditioned in the military to say that. Yes, sir, we can do it. And I thought, oh my God, wait till I tell the staff this one. And went down, and the geeks and everybody else had to start figuring out. We got some filed on, what was that thing called? Word Perfect, better than Microsoft Word. We came out looking at Arabic something stuff. It was just crazy. But they like the cable man, they got her done, got it done. You might not like the result. I don't care. We got that case done. And next day, argued, and next day the opinion. I actually released the opinion actually it was ready about 6 minutes till 9 that night, on Monday night. But I sat in my chair, the opinion's ready, and I sat there and I thought, 6 minutes till 9. The press should be able to say at 9 p.m. last night, not 8:50. So I'm just going to wait.
I didn't know that.
I sat there, and the sweep hand looked like it was slowing down. And everybody's waiting, phones up like this, because I had different attorneys. You call Ted Olson, you call David Boies, you call the clerk of the Florida Supreme Court. Don't forget them, right? You call this, and the press was standing by and everything. They're all there ready. And I just sat there and said, you know, once in your life, the whole world's kind of waiting.
And it was the whole world.
It was the whole world, yeah.
We had international press.
Oh, yeah.
Everybody was there.
I should have done. Devil made me do that one. So at 9 o'clock, I said, go. And the carts were taken down to the press, and they were devouring it and so forth. Now, I'm going to make fun of some of your colleagues, not you. Some grabbed it and ran outside to their sticks, the microphones they call them, and said, tonight the Supreme Court, you look at the syllabus. Law students, you know what the syllabus is? In the bottom of the syllabus, it says held, right? H-E-L-D. There was no syllabus. It was a per curiam opinion. Note to students, never go on television until you've checked out your notes, right? Now, you didn't get caught.
No.
A couple of your colleagues got caught
I know.
on the air with just saliva coming out of the corners of their mouth. You couldn't tell who won that case. There's no syllabus on a per curiam, right?
Right.
Who would have thought that? I was hysterical. I was having so
I
much.
told you he tolerates it with good humor.
Another
Pete
answer.
Williams of NBC News got it right.
He
by the
Pete
way.
got that one right. Yeah.
He beat everybody
Yeah.
on air.
But no inside information.
Right.
No, I got to. Nothing's ever leaked up there, right? You ever heard of an opinion being leaked?
Well,
Long time
Time ago.
Right? Maybe,
maybe, yes.
but not. About
Note left
12,
in a
14 years ago,
fireplace.
I had part of the Sealy organization. ABA had something called Central and East European Law Initiative. It was to help the countries behind the Iron Curtain, democracies, and it was a really good thing. A Bulgarian judge was visiting me, and he wanted to know how you administer a court. And he was a much older man than I was, and his English was good, not excellent, but pretty good. And he said to me, what do you do about security of opinions before release? And I said, absolute security, total, 100%. No one here has ever leaked an opinion. He said, leaked? I said, no one's ever leaked an opinion. I could tell something was wrong here. He finally looked at me and he says,
Oh, look.
I said, that's lick an opinion. Poor guy. We got that straightened out. Language is so much fun. But no, they have absolute security on that. So no one, they still do it, do they? Leak an opinion.
No, not in my experience. There was just the one incident, ABC News, and this was a long time ago. I think it predated me, where he was in one of the conference rooms and saw a piece of paper in the fireplace and picked it up and saw that it had something to do, I think it was Bakke, the Bakke case. And he went on to say that Bakke was coming down, and it was, I think he got the timing right, but
He didn't get the result.
no, he didn't get the
And
result.
he's also disciplined for violating the
Yes,
rules. He
yes.
was suspended from the court for 6 weeks, 6 months.
Something like that.
Yeah, I know him as a good friend,
Yeah, he's a good guy.
but they made one mistake.
Yes. In your 22 years, what do you think has been the biggest change that you've seen at the court? And that could be within your own office.
The biggest change in 22, automation. Oh my goodness, am I glad I'm alive to be in this age of automation. What a wonderful age. What geniuses created it, and geniuses operate it and make it go. Things that used to take forever, like death penalty cases. We had people up all night long. At 3 a.m., the Supreme Court did so-and-so. Doesn't happen anymore. As soon as something's filed in a district court, a habeas case, we have it right then. Court rules, we got that. Fifth Circuit gets it, we got that. The clerks are working on it in our court at the beginning of a case, not at the end. They start working on a memo. So what happens is on the night of an execution, you'll get an application to stay the execution and a cert petition. It takes 4 votes to grant a cert petition and hear the case. It takes 5 votes to stay the execution, which is kind of awkward if they vote to grant but don't get the 5th vote to stay the death penalty. That doesn't happen, fortunately. But now with automation, those things, one happened the other night dealing with another type of case, but not the death penalty cases.
That was unusual. That's when we got the 5 a.m. Saturday morning surprise in the Texas case, right? Voting rights case. And Justice Ginsburg explained that it was just the way the papers came in. Justice Scalia had to write a memo, and then she wanted to write a dissent. And by the time she got his memo and could write her dissent, she must have been up all night writing that dissent. But it's
very rare. So automation's the thing that happened most. And what a joy it was to implement that.
Do you, I always wondered this, but do you determine the schedule of arguments? Do you say when certain cases are going to be argued? And I'm thinking back to the first healthcare case when we had it over 3 days. How did that?
A difficult case like Obamacare case, which was spread over 3 days, it was lots of cases in one cases. That was decided by the court with the advice of the clerk's office and working with counsel as well. You just don't want to surprise counsel and say, here's the way your cases are going to be argued. It's better to get their input. The McCain-Feingold cases were long cases too. We involve counsel because they're so good and so reliable, and they keep confidence. As we say, petitioner responded, and you're amicus and so forth. How would you like to split this time up? And you tell us. We say, fine, that's nice. That's submitted to the court. The court says, this looks nice. And then we say, okay, file a motion. It's going to be granted. Why not? Why surprise you with something like that? The court is so friendly, it's unbelievable. So sure, we work that out with counsel to do whatever, but they don't always agree. You want an hour and you want 2 hours, yeah. The real good counsel know you're not going to get that. So that's why we rely on the real professionals. Not all in Washington, D.C., but a lot of them are there. And they're a tremendous help on that. But now your everyday case, usually those that are in first and are ready are argued first. The 22 years I was there, I have a young woman in the office, and she would set those up on the way we wanted to argue them. Monday, Tuesday, Wednesday, usually 2 cases a day to be argued. She would set it up, trying to have maybe 2 bankruptcies on one day and 2 religion cases the next, if you can, plus what counsel want to do. We get it all set. I send it up to the conference, that means to all 9 justices by a memo, and saying, this is a schedule for December. Now we've set December up. I plan to release this next Monday. Not one time did any justice ever call down and say, oh, no, let's flip these cases or do this or that. They are so smart, they know, don't mess with the small stuff. The clerk is fully capable with the staff of figuring out what should be argued when. They are so disciplined. It was just a joy to be there. I thought they'd say, oh, you switch this case. Never.
During your tenure, you served under 2 chiefs, Chief Justice Rehnquist and Chief Justice Roberts. Can you share with us any insights into the different styles?
Well, you have to remember this. Chief Justice Roberts clerked for Chief Justice Rehnquist and revered him. He loved the man and respected him greatly. There was no way he would ever come in and change anything or say one word about his dear late boss. And there's no need to. Chief Justice Rehnquist was a master at organization and keeping his colleagues happy. Well, they disagreed on this and that, but read all the biographies on Blackmun and all these others. They all liked Bill Rehnquist. They liked him. because he involved them in everything. What kind of flowers we plant in the courtyard, this and that. He had all these committees, and they all come together, and they get to decide, okay, it's petunias. Thank you, Clarence, for telling us this. So, they do this and that, and he was very collegial. Chief Justice Roberts slid right in and just kept going the same way. They're a remarkable group of very intelligent people who get along. I served for 16 justices, and 2 of them were chiefs, and I admired each one of them. Not a one of them ever made a demand or said anything to me or my staff that was untoward or in any way rude or something they shouldn't do. Not one time ever. They are remarkable people. They didn't just land there, they got there the hard way.
You mentioned Bush v. Gore. It obviously stands out in your memory as a particularly challenging case and time.
Yeah.
Any others that come quickly to mind?
It's interesting because sometimes just a little old bankruptcy case or ERISA case doesn't sound very important, but it's important to somebody out there, and it's important to a certain group of lawyers and bankers and this and that. So they're all kind of big cases, and to me, I just never got interested in bankruptcy and ERISA or, God forbid, patent cases. I'd rather just jump off that building over here than. And those if there was ever an afternoon case, I always schedule those in the afternoon because everybody's kind of sleeping and nobody's paying attention. Well, I mean, patents, that's not our job. That's up to the federal circuit to settle those things. But
We're getting a lot of those.
But I mean, there were a lot of cases. I mean, the VMI case was a fascinating case.
Good.
Fascinating because VMI was an institution, all-male institution, which had been there for so long, but all of us knew it wasn't going to stand scrutiny. Ted Olson made, in my opinion, the best argument he ever made. And I tell him this, and he says, I lost it 7-1. Justice Thomas was recused. And I said, but Ted, it was a great argument. You had to milk it for everything you could. Justice Kagan, the first case she ever argued in any court was Citizens United versus FEC. A born loser. You knew that.
Oh, I did, yes.
Look, it was re-argued with an additional question presented. I mean, the court is saying, here it is, baby. You know what we're going to do. And she knew it too. She gave a fantastic argument. Some people said, well, she could never argue a case. She was dean of Harvard Law School, solicitor general now. They're just setting her up to be on the court. Hey, she made 6 arguments, and she was as good as anybody I ever saw. She did her homework. Practice, and she's smart. So, I kind of like cases like that were doubly interesting. And the criminal cases, the religion cases are also, they were all a lot of fun. I liked all the cases.
Well, my understanding is that as you sat there during oral arguments, when the argument was over, you would sometimes circle who you thought would win.
Yeah, on
so,
the call sheet in red ink, I circled who I thought would win.
Right.
That was just your emotional thought of watching the justices, how you think things are going.
now it's time to tell us what your track record was. How good were you?
You know, about a low of 65%, and I think my high was 78%. So not very good, but some I wasn't listening to. I mean, I'm not interested in taxation. While I was up there, I edited 44 books for children, books about the law, and I did it for free. I was doing it on government time. And some were so poorly written, I really had to correct grammar of these PhDs and other people who were writing them. So I'd do those during tax cases and so forth. I mean, I could listen. I was doing my job, but I could also edit while I was there and do that. So those cases over, I'd say, circle. So yeah.
Okay.
But I got
Pretty good?
yeah, pretty good.
Yeah.
You could tell lots of times. Just by the body language and what was going on and what had happened in the lower courts. This isn't new stuff. I mean, the case has been in front of 2 courts at least. So you can tell, and no, I did not just reverse the Ninth Circuit every time. That's not. But it wasn't very good. But
Well, somebody else has his own theory, too. As you recall, before he became Chief Justice, John Roberts, when he was an advocate, he guessed on the number of questions a
Yes.
lawyer got. And the more questions the lawyer got, the more certain that lawyer was going to lose.
Yep.
And there's still, and he had a great track record with that. In fact, there's a law professor, I believe, who has
Yep.
a blog who still keeps that going, and he does pretty well.
It's almost like the old theory. You go to the racetrack and you look at the bill and it says they pick the favorites, number 1, 2, and 3, and you bet the one horse to show every race, you will win a little bit of money. When I was in law school, we did that. I didn't bet money. I just played like I was betting because I didn't have any money. And at the racetrack in New Orleans, and actually you'd win a little bit if you did that. So here, that's right, the more questions you're asked, and sometimes you can just tell. Some are just over before they even start. But don't tell the council that, and we treated all the council equally. They all think they're going to win.
Well, take us inside the lawyer's room before arguments. What's it like?
It's something I started up there. I found out when I got there, the lawyers who were going to argue a case would sit out in the hall, the great hall of the court. I just thought that was wrong from day one. So we took the lawyer's lounge, which looked pretty bad, and I decided we'll use that for a briefing. Well, what military do? A briefing before something starts. So I went up to Justice O'Connor, who was in charge of buildings and grounds. Right? And so I asked her if she'd come down and take a look at that place. And she said, "Oh, this is horrible. I've never been in here. I want this fixed up. Get this fixed up. Get the architect." Dude, she made things happen. And they turned it into a beautiful room, didn't they? Yes. Except one corner had nothing in it. And I asked the curator, I said, "We got to put something, a potted plant or something in there." She got a nice big statue of Daniel Webster, who argued about 200 cases at the court, I think, and it's just beautiful in there. So they come in the morning at 9 o'clock, and I give all the counsel and the co-counsel, and some students, if they're there with the professor, we let them come in too and sit in the back, little kids like this. And I tell them, here's what's going to happen today. Any questions? Can we help you? Check their attire. If their ties, if their collar is sticking up, or something like that. But believe me, sometimes they have horrible little things happen. Give them cough drops if they want. If they want a cough drop, I give them a whole box. Well, whatever they want, we take care of it. Then tell them what's going to happen today. Anybody recused? Then we all go in the courtroom. So they're all settled down. Even the most prominent attorneys up there. John Roberts sat there many times. He argued 39 cases before he became the Chief Justice. He said, when he became the chief, he said, "Bill, don't ever stop doing those briefings." He said that was the most wonderful thing because we came, we shook hands with each other. Sometimes you don't know your opponent. You could be from California, New York City, you shake hands, and it's a collegial thing. It's a collegial body. They're professional people. And he said, "I just enjoyed that every time. It's so good. Keep doing it." And I said, "Yes, sir, we'll keep doing it." But a couple interesting things happened. About 4 years ago, the Attorney General of a Western state, big, tall guy, never argued there before, had his new Armani suit on. He's ready to go. But as he started out the door to be escorted into the courtroom, I noticed I started to see a small problem. Actually, it was a large problem. His fly was unzipped. And it was open like 2 barn doors. Can you imagine arguing for an hour in front of that court, with all 9 of them just staring at your fly? So I walked up to him and I said, we use the term general. I said, "General, he said, "Ah!" I had to hold him up. I said, "It's okay. You're okay. You're all right." Interesting things. I had a fellow from Beverly Hills. Okay, this is going to be a good story. He came in and he said, "How do I look?" I said, "Well, you look fine." He says, "Well, I did exactly what you said in your little book. Gray suit, white shirt, no button-down collar, all the things you're supposed to wear." And he says, "I look all right?" And I said, "You just look great." Then I noticed something. Earring. I said, "Sir, I know you're from Beverly Hills. That's wonderful, but I'm not sure we're quite ready for the male earring up here. You'd be a first, but do you want to be a first or represent, He said, "Oh, he took it right off and everything." I said, "Only Beverly Hills would have that." But a guy got by me one time. I didn't see his earring. He looked like Joe Pesci. Remember the movie Home Alone? And that tooth he had, that gold tooth, would kind of shine like this? This guy had a little diamond stud in his ear. And I didn't see it until the argument started, and the lights there about like 3,000 watts shining down on that earring and bouncing up to Justice Scalia. He was real happy with the earring. And I thought, oh my gosh, and Joe Pesci's out there doing this and that, and bing, 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 going like that. I felt badly that I should have caught that little earring, but it's a therapeutic thing. They really enjoy it, and we did it. And I always enjoyed the students coming in. They just thought that was just the best thing that ever happened in their life, to get to see the real thing.
Well, I still find it a real thrill.
Yeah.
I do. What are some of the biggest mistakes that lawyers make at oral arguments?
Well, most of them have read my little book. I don't make any mistakes. It's on the website, A Guide for Arguing Counsel. I mean, it's right there. It's about 15 pages. It's the do's and don'ts. No flowery language. Just do these things, don't do these things, with nobody's name attached to anything. Sometimes they try to argue everything that's in the brief. Big mistake. Sometimes they try to argue. They should carry on an intelligent conversation rather than argue. Sometimes they get a little bit too folksy. Sometimes they'll ask a question back to a justice. These are horrible things that happen, but they should know better if they read it. And you don't see many mistakes up there. I'll tell you, be proud of the profession that you're in. The lawyers that go up there and argue, and again, you could be a first-timer from San Jose or wherever that, and go up there and do a great job. I've seen first-timers hit a home run. Home run because they were ready. They were ready. Those who have argued more than others, they usually do better because they just have more experience and they know what to do. But if you're prepared, you can do fine up there.
Have oral arguments changed much in your 22 years?
More questions from the bench. Mm-hmm.
Lots more questions.
Lots more questions. And there have been some justices who have mentioned that maybe we get too many. In one case, I counted 129 in 1 hour. That's almost 2 a minute, right? So I think you got to give counsel a chance to do the job. But they want to ask questions. Ask questions. They've read the briefs.
Right.
So that's the biggest change I've seen. I think the two, well, they all ask good questions, but the two that really I think are remarkable in the way they restrain themselves from asking a question until the right time, then they kind of pounce on you, is Justice Alito and Justice Kagan. Not that the others are not thoughtful. I don't mean that at all. I just mean they sort of wait. You think you've lulled them into the silence and everything, and then they got you. And once you get your nose between their teeth, you just can't let go, can you? So the questioning is good. It's healthy. Keeps everybody excited.
What have you found are some common misperceptions about the Supreme Court as you go around and talk to people?
Well, the first one is easy. And not casting blame, but too many people see the court through a political lens. Everything is politics. It's all politics. It's all politics. I'll debate anybody anytime. That is not. You show me a case, I see politics. I'll show you a case, no politics at all. Well, Justice Scalia, just a conservative, votes with the government all the time. Oh, no. How about the Coyle case? How about the search and seizure case? How about this case? No, it's not. You can take any isolated case and say, Citizens United, that was, No, they have to vote them one at a time. And so I think people think it's political, and I contend that it is not political. We have different ideologies right here in this room. And a lot of people, and Marcia's a wonderful reporter. I hope you know that. She's straight. She does it right down the line. There are some out there, though, they're just result-oriented. They want the result, and they report the result. And part of it is time constraints on television.
True.
They've got, 48 seconds to discuss a case. How would you like to discuss a Supreme Court decision in 48 seconds? The great Pete Williams does as good a job as could possibly be done on it. I think he's just terrific. But we're getting less coverage on television. We used to have every major network was covered. Carl Stern was there from NBC News, Tim O'Brien from ABC News. They were there all the time, but they cut back. So now her program is much more in depth. You get a lot more out of it. The average citizen isn't going to take time to do it. They're not even going to watch the 7 o'clock news because they're watching cable news, and they get, boom, the banner at the bottom. So-and-so loses case at Supreme Court. 3 banks robbed. It's just boom. That's the news, and you go on to the next case. So, and we don't teach it very well in our high schools and colleges. So I see that as a problem.
Do you have a favorite justice, living or dead? Which do you admire most?
I admire them all.
I told you he was good at not revealing anything.
I'll tell you a justice. Don't overlook reading about him and knowing about him, and that's Lewis Powell. Lewis Powell went to Washington Lee, was from Richmond, Virginia, a real Southern gentleman. Slow-talking, drawl. World War II came along. He was too old to be drafted, and he had too many children to be drafted. He joined anyway. He's a patriot. joined the Army Air Corps. We should have always kept an Army Air Corps. It's a joke between the Air Force, currently. And went over to it. He was in North Africa as an intelligence officer, and then moved up to England and worked for the OSS, which was succeeded by what? The CIA. They broke the ultra secret, the German code. He was on that team, a great American. He was over there for about 3 years before he came home. So he comes home, the war is over. Lewis Powell wants to practice law. He does so. Well, along came the American Bar Association. Lewis, we're having trouble. We need you to be president for a year. Please, Lewis, please. Okay, I'll do it for a year. Then in the 50s, late 50s, they integrated the schools in Richmond. Oh, Lewis, we need your help. You've got to be the school board. Okay, I'll do that. They had a peaceful integration of the schools there, racial integration. And then he said, now I'm going to practice law. Richard Nixon had trouble getting some of his nominees confirmed. Hainsworth, and I can't remember the other one, Clement Hainsworth and somebody else. So a delegation went down. They'd already asked Lewis Powell twice to be on the Supreme Court, and he declined. Can you imagine that? He declined appointment to the Supreme Court. He wanted to be in Richmond with his family, after all, fighting wars and doing all those things. So a team went down and said to him, Lewis, your country needs you again. And he said, went back to Washington. His wife said it was the worst day in their life. They didn't want to live in Washington. And served for, I believe, 18 splendid years, during tumultuous years. During the Bakke case, he was the swing vote in it. He did a lot of things. He also was the first justice to publicly dance with another justice. I said publicly. We never know back in the old days That's what they were doing up there. But he danced with Justice O'Connor after she came on, and he took her under his wing to show her the ways of being a justice on the court.
That's right.
He was a wonderful gentleman. He was retired when I got there, but he'd stop by my office, and I'd hear him outside. He says, is the general in? I'd like to talk to him. My secretary says, go right in, Justice Powell. He's right in there. And I'd get up and greet him. We'd sit down and just talk for maybe 30 minutes. It was enriching my life just to talk to this great legend. And I thought, you're so unselfish. You've given your whole life. You gave up the things you really loved to serve your nation. Most people have never heard of him. The great book written about him is written by John Jeffries, one of his law clerks, who was later dean of the University of Virginia Law School. It's called Lewis Powell, a tribute. It's a wonderful, wonderful book about a great life. After you read Marcia's book, read the book on Lewis Powell.
Okay, I'm going to wrap up pretty soon, so if you have questions for Bill, I think you all have cards, so take a little time right now to jot them down. I have to ask you, because it's discussed almost every year and it's on the media wish list, what do you think about a fixed camera, say, in the Supreme Court? Do you think it would change the arguments that are made, or how the justices would act? Just what are your thoughts?
Mixed feelings, but you asked me a question, I'll give you an answer. I'm opposed to it,
Okay.
for this reason only. I think that the outtakes from it would be used on the late night shows. I don't even watch them, but Bill Maher is one of the guys, and all these other jokesters, and make fun of the court, put words in their mouth, answer a question that wasn't asked, and it would be, ha, 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 the Supreme Court, look at those funny people. I'm not ready for that. I don't like it when they make fun of the president or members of Congress. Some richly deserve it, but I just don't, I think it's impolite. I'm sorry, it is impolite to make fun of the last bastion of what we stand for in this country. The Supreme Court is it. The Marble Palace is where things happen, and they really should, but we shouldn't be making a mockery. That would be the problem. The educational benefits, Dean, I wish you had it. Gosh, teaching advocacy would be great. Watching Seth Waxman or somebody up there. I mean, Seth Waxman was the Solicitor General under Bill Clinton. Seth still argues a lot of cases up there. I saw him argue one day after he was the Solicitor General. He's seated, his opponent is up at the lectern, and she's arguing, and some justice said, what page is that on? And she looked down, and she was frustrated. You ever done this? The harder you look, the more the sweat on the back of your neck, and you can't find it. Seth had the right page open and just put it right in front of her. That's his opponent. Now tell this to law students. Your opponent is not your enemy. She's your friend. I told that at a little luncheon one day, and Justice O'Connor was there, and I said, of course, you didn't see that. She said, oh, yes, I did. I saw that whole thing, and I told my colleagues that Seth is a real gentleman. That's the way it should be in the practice of law.
My final question to you has to do with what you're doing right now. Since your second retirement, you've been a visiting fellow at the Hoover Institution, and you've written several articles about the court's decisions. So did it feel strange to shift into a commentator role after all the years in which you had been so guarded about your own opinions of the court and its decisions?
I watched you and your colleagues for 22 years, so I thought I'd get pretty good at it myself, but I'm really not good at it yet. But no,
You like it?
Yeah, I'm having fun. This third career is great. And part of it is, too, with the Lyme disease, I'm working on that. And I read one time where that you should say the first half of your life you should seek success. Promotions, income, responsibility, right? The second half, seek significance. And there's really something to that. The older you get, the more you really think, and I've seen people do it. I have a friend, he's a retired general in the Army. When he retired, he didn't know what he wanted to do. Two-star general, lawyer, didn't know what he wanted to do, didn't want to practice law and this and that. My sweet wife convinced him to come out to her school one afternoon a week or something for 2 hours and help kids learn to read, especially those English as a second language. She said, Bob, come on out and help. Well, he reluctantly went out and he helped a little bit, a little more, a little more, a little more. The kids started showing advancement. Little Juan was doing better and better and better and better. That developed into now where he is teaching almost full-time, teaching autistic children. He got an award a few years ago at a military organization meeting one night at a banquet, and he got up to receive the award, and he said, I have to tell you folks something. He said, I've been hit, I've had chairs thrown at me, I've been bitten, I've been cursed, but he said, when the day is over and a little kid comes up and gives you a hug and says, Mr. Murray, please come back tomorrow. He said, I've never been happier and feel more secure in my life. Isn't it interesting? And then he pointed to my wife and said, this is all caused by an angel named Jeannie Suter who got me off my rear end and got me out doing something worthwhile. That's significance, right?
Okay, I'm sorry, one more question. I can't let you go. You have to tell us about Elvis Presley.
Thank you very much. It just worked out that Elvis and I were at Fort Hood, Texas at the same time. He was a private. I was in training. Our barracks were next door to each other, and we'd see him and talk to him. And you've seen the picture of Elvis and me on my desk. It's on the website, too. It's all over. Once you put it up, it's everywhere. And he was just a good old boy who got drafted, probably the last publicity person who ever got drafted. They all found reasons not to. The media asking him, Elvis, why didn't you get a lawyer? Why? He says, I thought it was my duty to get drafted. Of course, he lost a lot of money. They let him live off base at Killeen, Texas, but at Fort Hood, he was a regular soldier. I drank beers with him. He didn't drink too much. In fact, they gave us beer that wasn't real beer. They put us in a cantonment with wire around it so we couldn't get out, and we get to drink a bottle of beer in there. Boy, thanks a lot, Army. It was 3.2 beer. You ever hear that? It's called near beer.
Near beer.
But he wasn't a drinker much. Got haircuts with him. Remember that? Went to the laundry one time with him, but he was just a good old boy doing his job. And when the Army changed from brown shoes to black boots, they gave you a bottle of dye so you could dye your boots. Well, thank you very much. When it rained, it all just went off. Elvis went out and bought everybody in his company, 150 soldiers, all new boots.
Wow.
But nobody fleeced him out of his money. He just gave it away. He didn't care. But he was a good soldier. And he did his duty.
Okay.
And I taught him everything he knows.
Did he teach you to sing?
No.
Okay, we have a question. Do the justices hold conferences to discuss their opinions before writing them? How do they reach decisions?
Basically this, when a case is argued on a Monday, Monday, Tuesday, Wednesday, they argue 2 hours a day for 2 weeks in a row, October through April. Got it? So each is a session, 7 sessions. When a case is argued on a Monday, I'll just simplify it. Usually 2 days after a case is argued, they meet in a conference room, 9 of them, and they go around the room. No one's in there with them, just the 9, and they express how they're going to vote on the case. And let's say it's 5-4, and the chief's in the majority. The chief, the senior justice in the majority, assigns the opinion to one of them to write. So Kagan will never assign an opinion to anybody, right? She's junior. They assign it. that's the end. They go back to their chamber, they start writing. When they finish, let's say it's Justice Ginsburg writing it, and she's in the majority. She then finishes her writing, 2 weeks, 3 weeks, 4 weeks, 5 weeks, sends it around in an envelope that's marked confidential to the other justices. Then they write back, and they write back a memo. One of them will say, "Dear Ruth, please join me in your opinion." I know it sounds archaic, but it means I believe every word you said. Signed, Steve Breyer. So she says, okay, that's 2 votes, me and Steve. Nobody's changed. Another one comes in, another one comes in. Then she's waiting on that 5th vote. Oh my gosh, oh my gosh. Well, here comes one. Opens it up. "My dearest Ruth, I admire your scholastic ability and your writing. However, I disagree with your interpretation of the 14th Amendment. I shall file a written dissent. Yours faithfully, with all best wishes, Nino Scalia." They're good friends. Now, everybody sees everything that everybody else writes. She might write all of them back and said, "I've seen Nino's note. I really didn't mean that about the 14th Amendment. I believe in the Privileges and Immunities Clause. That's what we're going to go on here." They kind of deal back and forth. They don't sit down in a huddle and argue and fight. They don't do it. And they basically have this rule in conference. 9 of them, right? Oh, if only faculty meetings were this way, Rachel. Everybody speaks once, nobody speaks twice. State your business and then shut up. And you go around the room. That is a good rule for any organization. Because if you haven't said it yet, too late, Charlie. And go back. Now you can change your vote or anything else, but let's just don't sit here and gab. Let's get on with it. So that's the way it's done. Finally, the concurrences are written, the dissents are written, they're all circulated, and then they all come out on the day at the same time. But look, 40%, the time I was there, an average of every year, 40% of the opinions were unanimous. Last term, it was 65%. I couldn't get 9 of you to agree what to have for dinner tonight, right? I mean, you don't, no, I don't want chicken salad, I want turkey salad. They agree to agree or disagree. They're very disciplined. Get it in and get it out. Just griping about it's not going to help anything. Now, admittedly, some of the tougher decisions come out later in June. That's just the way it works.
And they have some traditions that help with collegiality, right? The shaking of the hands.
The shake every time before a conference and every time before an argument. They all go around and shake hands with each other, which means we're friends. We have differences out there, but in here, well, we're friends.
It was also my understanding that Justice O'Connor was someone who said during conferences, if they break for lunch, they don't talk business.
No business
She
talking
said
at lunch.
Only
After oral arguments, they always have lunch together. Don't talk about the case. You're better off that way. You might get into a food fight.
Okay, many lawyers and judges believe their oral argument does not affect the outcome, or rarely does. Does that hold true for the U.S. Supreme Court?
I'll quote the justices on that because I've heard them ask this question many times. It's an old saying, but it's worth saying again. You can't win your case at oral argument, but you can lose it. And on occasion, I've seen a case granted. That means the lower courts, it's come all the way up, 4 votes to grant, important federal question, the case is briefed, it's argued, and after argument, we dig the case, D-I-G, dismissed as improvidently granted. So something happened during that oral argument.
Yes.
They might decide, this is a state law question. We don't decide state law questions. But a dig is as good as a win if you're the respondent, because the lower court holds the same. So yeah, it makes a difference. The oral argument can make a big difference. Plus, I think it's good for Americans to sit there and see it and get it out of their system. And this is our conduit. Without a free press, you wouldn't know what's going on in that courtroom. We rely on them to tell us, and they tell us what happens. She's got a great job.
I do.
I might try to get your job.
Any other questions? I'll even take them from the audience now if you haven't written anything down. Yes.
That's a rumor. One way you can tell who writes them is term after term after term, a certain justice, his or her style doesn't change. If you had different people writing, the style would change. You can just tell they write it. Now, I might draft out something and I'll tell you, go find the footnotes, Or worse yet, go find the laws of all 50 states on domestic violence, and I want that in a footnote or something like that. Boy, that is scud work there. Yeah, but the law clerks do that kind of work, but the justices do their own writing. They really do.
And they do for the most part. They all have different ways of approaching it. When I was interviewing some of them, I asked them to tell me how their chambers operate, and I was told by by Justice Stevens and some former clerks that Justice Stevens would often it depended on the case. Sometimes he would give a broad outline of how he wanted the opinion written, and they would do a first draft. Sometimes he would be very specific and write the first draft himself, and then just see what they thought of it, and then redo the opinion. Justice Kagan said she likes to have her clerks write a first draft, and she puts it up on her computer on one screen, and then she has a screen for herself. And really, the first draft just gives her a sense of what they're thinking, but you can tell a Justice Kagan opinion. It's clearly her own. Yeah. And the Chief Justice, he writes his opinions in longhand on a legal pad, and you can always tell a Roberts opinion. So Bill's right, they have very distinctive styles, and that's not something a clerk really can mimic and do it every year with a new clerk.
And they're all tech savvy. When I got there, the Chief Justice Rehnquist and Justice Suter did not have a computer on their desk. Didn't have one.
We're not even sure Justice Suter still does.
He doesn't.
Is now.
He doesn't. He had trouble with that phone with those buttons on it. Look, I mean, he's a wonderful, wonderful, wonderful guy, I got to tell you. Great sense of humor for a Yankee. But, no, I just mean they have a sort of a droll sense, but I loved him. He was great, but he didn't want that newfangled thing. He didn't even like lights on in his chamber.
That's right.
Go up there in the middle of the winter, and Justice Suter, you in there? I'm over here, Bill, by the window, reading Shakespeare.
Yeah.
He's quite a guy. Here's one here. Yes.
Yes.
Mm.
Some of us who are in the legal community are pretty appalled about some of the justices not recusing themselves when they have what in any other jurisdiction would be clear conflict.
Sure, I will. One difference about recusals is if you're a U.S. District Court judge, there are about 700 or so, circuit court judges about 60 or so, if you recuse, somebody can take your place easily, right? They just do it. In the Oklahoma City bombings, a good friend of mine, Judge Wayne Alley, a retired Army general, had that case. But his office was bombed, and McVeigh, they made a motion that he be recused. He wouldn't do it. 10th Circuit said, when a circuit court says this, Mr. Justice, out of an abundance of caution, what it means is we don't know what we're doing either, but you better get off the case and put somebody else. So they put Judge Maitch on it. He was tougher than nails. But somebody can take your place. Up there, by law, it takes 6 to make a quorum. 28 U.S.C. Section 1. Not 5, it takes 6 for a quorum. So you start saying, oh, my fourth cousin has an interest in this case, or I own 1 share of stock in Ford Motor Company or something like that. It's got to be something significant before they recuse themselves. I mean, this happens, they recuse when it's obvious. And they ask counsel, their own record, you tell us if you think there's a reason. We almost never get motions to recuse for anything. There's really no reason to. I mean, there was a lot of noise that Justice Kagan should have recused herself on the Affordable Care Act cases. It doesn't matter what I think, but my own personal thought was, no, she was in the Solicitor General's office, but that case never came across her desk. Did she ever talk about it? Of course. I mean, of course we talk about things. But you go in there with a level head, fair, and do it. But again, the standards are different in the lower courts. Up at the big time, and if we don't have 6, we can't decide the case by law. It's remitted to the lower court, and the lower court standing. So you're not getting your money's worth. There is some talk, especially in academia, we should have a backup system. We have 3 retired justices now. They're still sitting on circuit courts. Well, Stevens is not, but Justice O'Connor, Justice Suter, they can sit on circuit courts. Did you know that? But they can't sit on the Supreme Court. Perhaps they should rotate in one, then next case another one, and fill the vacancies. I happen to think it's a good idea, but I don't think it's going to gain any traction. There's no interest in Congress. Law professors are writing about it. They should keep writing to come up with some kind of a system, because you should get your money's worth out of the Supreme Court. But I've never seen a case that appeared to me that any justice should recuse himself or herself where they didn't do it. Now, you might say close case or this or that. It just doesn't happen. So that's probably the last question.
Last question.
That's
Okay, it's,
Oh, yes, sir.
sure.
Oh, good.
Marcia, do you agree with Bill that politics does not enter into opinions? In other words, the justices don't sit as liberals or conservatives, they decide. That was an interesting part of your book, and I'd like you to share that with the audience.
I do agree with Bill for the most part. I think right now we're in a period where it's very easy for the public to believe there's politics because of the way that the court is structured. We have when the court splits 5-4, and it splits most often 5-4 ideologically, you have 5 Republican appointees and you have 4 Democratic appointees. It's the first time in decades that we've had that kind of alignment between the court and the appointing president. So it does look that way. I try to tell people that the way I look at the justices, and I hope all judges, to be honest with you, is that you're naive if you think they come to each case with a clean slate. They are, like all of us, the product of their education and their experiences in life, and they're going to bring that to bear on the cases before them. But do I think when John Roberts sits down to decide a case that he sits, well, I'll tell you, one of the justices I interviewed said very similarly, do I think when I sit down to write a case about what's good for the Republican Party? No. Do I think when Ruth Ginsburg sits down to write a case that she thinks, what's good now for the Democratic Party? No, I don't think that. But the results are what they are, and it's because they have different ideologies. When you get a case like Bush v. Gore, it does test that belief that they are doing what they feel is best and what is the law. But in general, I don't believe they play politics. I think it's the product of how they see the life in law. And presidential elections count. Your vote counts. So if you're not happy with who's on the Supreme Court, then you should think hard about who you're going to vote for president, because you will get. It's logical that a president is going to appoint a justice who he or she thinks is compatible with the president's own ideology. Is that fair?
I agree. I agree with you.
Thank you both very much. Please join me in thanking our guests.